Well, thank you very much. Thank you, Luis. It's always a challenge to follow one of Thomas's presentations. He really offers such a unique perspective on many of these issues here, having been an active participant in some of the most important cases in the area. But I hope to try to build on a few of the points that Thomas raised here based on U.S. experience in the recently concluded Google investigation and also the earlier Microsoft case about the role of competition in promoting innovation in the digital economy. And the central point I want to make is this. Competition policy in the digital age needs to take innovation seriously. I think we've heard this point made by earlier speakers here. And really this means, I think, on the one hand, not engaging in overly aggressive enforcement that may chill a business's incentives to innovate by, for instance, developing a better product, releasing an improved product that may have harmful effects on competitors, but not necessarily on competition. And this is a point that we've heard repeatedly in the Microsoft case, for instance, that Microsoft was providing a better product by integrating the browser into the operating system. So therefore, you competition authority, if you intervene in this, you're really going to be chilling our incentives to innovate. And I think you hear the same arguments by Google, both in the United States and in Europe. But at the same time, I think we need to step back and recognize that in certain circumstances, particularly the types of situations that Thomas mentioned, where there is cogent evidence of likely anti-competitive effects, that not acting in those appropriate circumstances, when a dominant technology firm, for instance, engages in exclusionary conduct against an innovative rival or potential rival, that also can have very important harmful effects on innovation. And I would submit that in the US context, I think the former concern about chilling innovation tends to get the most attention, and it is a serious concern that antitrust authorities have to recognize and have to be careful about. But I think the latter, the concern about what happens if we don't take appropriate action, doesn't necessarily get enough attention. Now, before addressing either the Google or the Microsoft case, I just want to briefly provide some very basic background on the legal framework through which those cases were analyzed in the United States. And under the US laws, we don't have an abuse of dominance provision, we have a monopolization provision. And so single firm conduct is addressed under Section 2 of the Sherman Act, which makes it unlawful to monopolize or attempt to monopolize any part of interstate trade or commerce. Now, the courts have interpreted the offense of monopolization as having two elements, one of which entails the willful acquisition or maintenance of monopoly power. In other words, anti-competitive conduct, as opposed to developing a better product, possessing better business sense, or just plain having good luck. Now, the antitrust courts over the years have observed whether any particular act is anti-competitive or exclusionary, as opposed to being vigorous competition, can be a difficult question to try to discern. It's partly because there are countless ways to compete legitimately, and there are also many new and inventive ways of engaging in illicit exclusion. So the challenge has always been in stating a general rule for distinguishing between exclusionary acts, which reduce social welfare, from competitive acts, which increase it. And in many instances, I think that challenge may be especially difficult in fast-moving technology markets. But in the United States, then, one of the key principles that has emerged under Section 2 case law is that for monopolist conduct to be condemned, it must have had an anti-competitive effect. And what that means is, as interpreted by the courts, that it must have harmed the competitive process and thereby harmed consumers. So it's not enough under US law to show that competitors were harmed, consumer harm really is the hallmark. I just mentioned really briefly here Section 5 of the FTC Act in theory allows the Federal Trade Commission in the United States to address conduct that goes beyond what is otherwise covered by Section 2 of the Sherman Act, and but the scope of that really isn't particularly well defined at this point. But there was some hope, I think, or some discussion prior to and during the Google investigation that the FTC might have used that case as a pure Section 5 case. Now, Thomas has already discussed many of the search issues that were the subject of competitive concerns in the European Union, and many of those were also the same concerns that were brought before the Federal Trade Commission. Now, in addition, the Federal Trade Commission was also dealing with some standard essential patents issues, which are also some very important competitive issues currently on the radar screen of both the Department of Justice and the Federal Trade Commission, but I'm going to not be addressing that this afternoon. Now, in January of this year, the FTC concluded its investigation. And for a case that at one time seemed like it had the potential to become the next Microsoft case, it ended with kind of a fizzle. The FTC obtained a voluntary commitment by Google to remove restrictions on the use of its online search advertising platform that may make it more difficult for advertisers to coordinate online advertising campaigns against multiple platforms. And Google also agreed, again voluntarily, to give websites the ability to opt out of being displayed on Google's vertical properties. But really the core allegations, which are what Thomas was talking about here, about the integration of vertical search into Google's horizontal search engine, ultimately that investigation was closed without really any action being taken. Now, in concluding its investigation, the Federal Trade Commission issued a statement describing the reasons for its decision. And those reasons focused on the question of consumer harm. Now, the agency stated that, according to the evidence, Google's primary goal in introducing its own vertical search results was pro-competitive. And the agency concluded that really what we had here was a situation where I go to Google, for instance, and I type in Microsoft's stock price, and Google gives me not just a list of links to where I can go find Microsoft's stock price, but actually gives me that stock price. Or if I want to find airfare from Santiago to a destination in the United States, and I'm looking for that airfare, to not just give me links to where I can find that, but to actually give me results from its own vertical search properties, the FTC seemed to conclude that, well, that is something that's beneficial to the consumer. That's what the consumers want. And the agency, I think, took the view that given the pro-consumer benefits, they were very reluctant to engage in any sort of second questioning of Google's product design. The FTC noted, for instance, that an important dimension, product design is an important dimension of competition, and therefore condemning such product improvements where reasonable minds might differ as to the best way to design a search result page risk harming consumers. But like I said, in the United States, I think that hesitancy to engage to intervene in cases of product design is really a strong hesitation in the antitrust context, and there's certainly a very reasonable basis for that. Now, as many of you know, the Microsoft case also involved product design practices, where the government challenged certain decisions by Microsoft, excuse me, such as its technical binding of its Internet Explorer web browser to the Windows operating system, for instance. That was a product design decision. There, the courts did impose liability for those decisions. And despite the fact that the DC Circuit on appeal also expressed concerns about the possible harm to innovation from antitrust agencies getting involved in those types of decisions. But there really isn't necessarily any inconsistency between those two cases. As to the design decisions for which Microsoft was not able to provide some kind of plausible, pro-competitive, pro-consumer justification, Microsoft lost. In those cases where Microsoft did proffer some kind of pro-competitive justification, for instance, overriding the user's browser choice with regard to help files, or the restriction on replacing the Windows user interface, where those types of pro-competitive justifications were given by Microsoft, Microsoft prevailed. And at least in terms of what we see from the FTC, that decision not to proceed against Google, and it seems to have been tied to that proffering of pro-competitive justifications by the company. Now, one important point to make is once conduct was found to be anti-competitive in the Microsoft case, the court did not require proof of causation in the usual sense. Instead, in the context of a dynamic market, the DC Circuit concluded that it was sufficient to infer causation when exclusionary conduct is aimed at producers of competitive technologies that are still in their infancies. And that really makes sense, that, as the court noted, monopolists should not be given free rein to squash nascent but still unproven competitors at will, particularly in industries marked by frequent paradigm shifts. Now, unfortunately, unlike in Microsoft, in the Microsoft case, Judge Jackson, who was presiding over the trial, issued a multitude of findings of fact, 412 paragraph length findings of fact, where find out all of the factual bases that informed the legal conclusions that it ultimately reached. And unfortunately, the Google case is hard to really get a good sense of what the commission was thinking, other than just generally the fact that Google proffered some pro-competitive justification, because the statement by the FTC is only a few pages in length. So we can only really sort of take the FTC at its word in terms of those justifications, but I'd certainly be interested in hearing Thomas's thoughts during the panel on the process that may have been going on there. So, lessons from Google. Now, after the FTC investigation concluded, we saw a lot of commentary on the case in particular and on antitrust enforcement in the digital economy more generally. One U.S. scholar, David Evans from the University of Chicago, shared his thinking on what he termed the broader questions that the decision raised. And looking back at the high-profile investigations in the United States and in the European Union over the past 30 years, from IBM to Google, Evans concluded that every time we think we have found a firm in the IT sector that was so dominant and so unstoppable that it could live the quiet life of the monopolist, we quickly see those firms upended by innovation. And one of the examples that he gives to support his thesis was Microsoft. And you look back at Microsoft during the days of the investigation by the DOJ, by the European Commission. Early on, Microsoft in the early 2000s seemed like a super dominant firm that would be essentially impossible to dislodge from its position in the market. Apple at the same time was largely irrelevant. Now, however, Apple's market capitalization is about double that of Microsoft's, and the great competitive battles of today involve Amazon, Apple, Facebook, and Google. Microsoft is hardly a player in many of these battles that seem like they're going to be defining the future of competition on the internet. So on that basis, Evans concludes that perhaps it is time for antitrust authorities to give this sector, the IT sector, a rest. Now, this conclusion, of course, is by no means unique to Evans, and is certainly not new. We saw the same arguments made in the Microsoft case. And it's basically the same argument that Thomas was addressing here in his talk. But let me suggest that Google and Microsoft do not, in fact, support the conclusion that antitrust enforcement in the tech sector should be given a rest. And at least two reasons here why. First, looking at Microsoft 10 years later, there's little doubt that the company's position in the broader IT market has in fact declined, in fact in some ways has declined precipitously. However, I think in some ways Microsoft's demise is greatly exaggerated, particularly in relevant product markets such as PC operating systems, office productivity applications, in which it has long been dominant and which were the subject of, at least in the United States, many of the enforcement actions. So consider, for instance, you want to start a new law firm, and most likely you'll have to go out and you'll have to buy a Windows-based PC to run your document management software. Most likely you will need to buy Microsoft Office so you can exchange documents with your clients. So query whether, in fact, Microsoft's position really is appreciably different than it was a decade ago or even 20 years ago. Now, while the IT industry as a whole might be dynamic, we do see instances then of long-lasting dominance in very important markets due to issues like network effects and some of the other factors that Thomas was talking about, even if the relative importance of those markets within the broader IT sector may have declined over time. A second reason, then, why I also think this is wrong, and perhaps more important reason, is that even looking at this broader IT sector and all the changes that we've witnessed over time, we cannot ignore the fact that these changes that we've seen in the IT market over the past 10 years or so occurred against a backdrop in which the United States and the European competition authorities had imposed very real restrictions on Microsoft's business practices. Remember, Google itself came into existence in 1998 during the time of the Department of Justice's investigation of Microsoft. Had Microsoft's exclusionary practices in the browser market not been challenged, it is certainly possible to imagine a far different competitive landscape today. I'm always hesitant to try to engage in these sort of counterfactual histories, because it really is impossible to say what they would look like. But recently, Dave Heiner, who is Microsoft's general counsel, wrote an interesting article describing the various manners in which EU and US remedies affected the company's conduct, or at least limited its competitive options in ways that are relevant to some of the most important developments in the IT sector over the past decade. And I want to just quickly highlight two of those areas that Heiner mentions. The first that deals with Google itself. Early on, Google was able to obtain rapid success by reaching consumers using Windows PCs. It did that in part through agreements with browser developers like Firefox and with PC manufacturers like Toshiba to feature Google the search by default on their products, even within the user interface of Internet Explorer in some cases. Query whether that would have been possible had Microsoft not been subject to antitrust scrutiny. The second relates to Microsoft's decision in response to the European Union case to publish various protocols, including Exchange ActiveSync. Because Google and Apple and BlackBerry have all licensed that protocol from Microsoft, your iPhone or your Android phone can all send and receive emails from Microsoft Exchange servers. Those servers, those email servers, are widely deployed in corporate and government settings. And while I have no market research to back this up, I suspect an important part of what helped transform the iPhone from really cool gadget into the sort of platform success that it ultimately became was the fact that it was able to become a serious enterprise device. Again, query whether that would have happened and how this smartphone landscape would look today had Microsoft not been subject to antitrust scrutiny. So whatever the deficiencies of the remedies, I think the US remedies were deficient in trying to help remedy competition in the OS market itself, but I think a compelling case can be made that the combined US and EU remedies were quite effective in protecting competition and innovation in adjacent markets. And over the long term, that really may have been the most important legacy of that case. Now, I just want to return to the central question for the FTC in the Google matter, and generally under Section 2, which is harm to consumers. In the Microsoft case, there were two kinds of harms that were identified by Judge Jackson. One was what he called immediate and easily discernible harms that included consumer confusion, for instance, degraded system performance, increased technical support costs, and the like of Microsoft's decisions in terms of binding the browser to Windows. And those immediate harms seem analogous to the types of harms or lack thereof that were described by the FTC in the Google case. Harms or benefits right now, today, in forms that I can readily discern. But in Microsoft, Judge Jackson also determined that the company's conduct had caused less direct, but nevertheless serious and far-reaching consumer harm by distorting competition. In concluding his factual findings, Judge Jackson wrote quite powerfully that the ultimate result of Microsoft's conduct was that some innovations that would truly benefit consumers never occurred for the sole reason that they did not coincide with Microsoft's self-interest. Now, if the narrative I have sketched here is correct, over the long term, these harms to potential future innovation far outweighed any of the immediate and easily discernible harms that the court identified in the Microsoft case. And I think it's these harms, really, that somehow competition authorities have to try to find a way, at least in the United States, the U.S. law has to grapple with how to take these kinds of harms seriously. So where does this leave us? First, I say competition policy does have, I think, an important role in protecting innovation in the digital economy. Second, in order to play that role, I think it's important that competition policy take a long-range view. As Tim Wu from Columbia University recently noted about the AT&T cases in the United States from the 1980s, early 1980s, that the short-run effects of the lawsuit were ambiguous, but that over the long run, the telecommunications market went from stagnancy to vibrancy and spawned many new markets, many of which never would have been dreamed about at the time. Now, the challenges of innovation-centered competition enforcement are many, not least of which is the fact that the merits of conduct challenged, in many cases, generally can be debated by reasonable minds. As a result, one frequently hears sentiments like those expressed by FTC Commissioner Olhausen, who in voting to close the Google search investigation wrote that poor or misguided antitrust enforcement action in fast-paced technology markets can have detrimental and long-lasting effects. And that's true. But on the other hand, I think given the extent to which exclusionary conduct by dominant technology firms can restrain future innovation, poor or misguided decisions by enforcement agencies not to take meritorious enforcement actions can have equally detrimental effects. Thank you.
Muchas gracias.